Yeah, good afternoon. This is Desai from Nishith Desai Associates. We are just starting our webinar, which is on the cross-border perspective on the interaction between arbitration and insolvency. I think it's a pretty important topic from our perspective because while we have seen a huge intake of disputes and particularly use of arbitration in international transactions in last decade, what has also happened is we have already gone through a couple of cycles of economic downturn in last decade. And 2020 with COVID-19 situations, we are possibly going through some other restructuring, bankruptcy cases as well. And therefore, even those cases are at surge, which means while trade disputes, commercial disputes, shareholder disputes, joint venture exits, private equity exits, all of that would continue into dispute resolution mechanisms. There will be an definite overlap and interference of various insolvency and bankruptcy regimes, even if it is limited to restructuring, and how does it affect those arbitration proceedings. So we thought it might be a good idea to talk about this topic, and that's why we are here before you. And thank you all the participants to join in this numbers. So we have an excellent panel. We also have first our partners who have joined hands to co-host this session. Kushal Gandhi from CMS London. He's a partner at the London office and does a lot of international dispute resolution, particularly focusing on finance and economic litigations. We also have Emily Sonderesen. She's a barrister based out of London. And we also have Abhinav Bhushan from ICC sitting in Singapore and giving a perspective as to how the institutions are looking at these situations, particularly when cases either get suspended or get affected due to some of these insolvency issues, and also what are the mechanisms to resolve some of these situations. So we have very good perspectives both from London and Singapore. And also I have my colleague who is a senior member with Nishith Desai Associates, sitting out of our Delhi office, Resolution and Investigations Act, NDA. So with that brief introduction, let me straight away get on to the topic and bring in Kushal first. Kushal, you can also spend a minute or two, to introduce yourself based on your experience and expertise on this topic as well. But with that introduction, I also want you to kickstart the discussion. Whenever disputes, you obviously tend to either, start a civil proceedings / arbitration, initiating arbitration for basically adjudicating the dispute and, getting your claim. But in the meantime, you also have options for starting an insolvency proceedings, at least in India, where if the debt is due and not disputed, you can actually take the company to restructuring under the new Insolvency and Bankruptcy Code of 2016. How does it work in UK? Is an arbitration clause a bar to go into insolvency? Do you have to meet certain thresholds? Can you do both parallel? How do you tackle strategically when a client is faced with such a situation?
Great, thank you very much, Vyapak. I don't think I need to introduce myself because I could not have done any better a job than you did. So thank you very much for that. So to answer your question, maybe if I just bring my slides up, because that's a very good starting point that you've highlighted. And on my sort of first slide, what the question I'm going to answer is the one that you asked, which is, what do you do when you have an arbitration agreement? And generally, when you have an unpaid debt, an effective tool to get recovery is the threat of a winding up petition. However, this can be prevented if the debt is genuinely disputed. And what I'm going to cover in the next 9 minutes or so is what happens where there is a sum due from a counterparty and the underlying contract has an arbitration agreement. I will focus on the English law position, and the starting point is whether the creditor can present a winding up petition in relation to sums arising from an agreement which is subject to arbitration. This was analyzed by the English courts in Salford Estates. And what I've done on my next slide is I've set out what the English court held in Salford Estates. So generally, under the English Arbitration Act, there are mandatory stay provisions in Section 9, which enable a party to an arbitration agreement to obtain a stay of legal proceedings in respect of matters covered by the arbitration agreement. This does not apply in the context of a winding up petition. However, what the court said is that Section 122 of the Insolvency Act confers on the court a wide discretionary power to wind up a company. This then forms the basis on which the court takes into account the arbitration agreement. If a debt is not admitted and falls within the terms of the arbitration agreement, that can be sufficient for the court to consider the debt to be disputed. And other than in wholly exceptional circumstances, and I'll come on to talk about what those would be, it is not appropriate for a judge to inquire whether the debt is disputed in good faith on substantial grounds. This is a very high threshold. And on my next slides, I delve a bit into what is wholly exceptional circumstances. In the recent case of Tenlick and Nip, the English court provided guidance on this. In that case, Tenlick was a debtor and Nip was the creditor. It was Nip's position that there were wholly exceptional circumstances in this case which enabled the court to inquire whether the debt was genuinely disputed, as opposed to deferring the question to arbitration. In doing so, Nip relied on the following. One, the debt was admitted in correspondence, but Tenlick said that this correspondence was without prejudice. Tenlick was anyway balance sheet insolvent. Tenlick had made an unlawful distribution to its shareholders, and Tenlick had tried to slow down the arbitration or failed to participate in it in good faith. However, none of this was sufficient for the court to decide that wholly exceptional circumstances existed in this case. You can see the court has set a very high bar for what would need to be shown for them to inquire into whether or not a debt is disputed when you have an arbitration agreement. And the court reiterated the need to avoid an investigation into whether or not the debt is bona fide disputed on substantial grounds where you have an arbitration agreement. That very much is something that should be determined by a tribunal. I hope that gives you a bit of an insight, and that answers your question a little bit, Vyapak, into the interaction between arbitration agreements and commencing in English insolvency, at least.
Sure.
The next thing I wanted to just touch upon is the English law position in the context of arbitration and commencing foreign insolvency proceedings, because sometimes what you may have is you may have an English law agreement with an English seat, but the relevant entities may be based abroad. So again, just to look at that, where you have an English law governed arbitration agreement or an English seat in the arbitration agreement, careful consideration should be given to commencing foreign insolvency proceedings that touch upon matters within the scope of the arbitration agreement. This exact issue came up in the recent case of Riverrock and the International Bank of St. Petersburg. And in that case, the English High Court granted an anti-suit injunction in relation to claims being made in foreign bankruptcy proceedings, where the underlying agreements that included the arbitration provisions with a London seat. So again, to put this in context, the factual background was that the International Bank of St. Petersburg was a large retail bank incorporated in Russia. The bank was placed into provisional administration by the Central Bank of Russia in October 2018, and bankruptcy proceedings had commenced in respect of the bank before the St. Petersburg court in November 2018. The bank was declared insolvent in September 2019, and the Russian State Corporation Deposit Insurance Agency was appointed as its official receiver in bankruptcy. Riverrock, on the other hand, is an English company regulated by the FCA. Between January to July 2018, Riverrock and the bank entered into 9 substantially similar contracts. I'm not going to get into what the contracts were about, but suffice to say they were substantial and there was a lot of money involved. But importantly, all of the contracts were governed by English law and provided for resolution of disputes by a London-seated LCIA arbitration. In October 2019, in the context of bankruptcy proceedings, the bank commenced proceedings in St. Petersburg, seeking the invalidation of the contracts and relying in particular on certain provisions of the bankruptcy law and civil code of the Russian Federation. On my next slide, I then set out what happens in the context of an anti-suit injunction. So Riverrock applied to the English court for an anti-suit injunction in respect of the St. Petersburg action, because suddenly they were left in a position where they had an English law governed contract with an arbitration clause that the St. Petersburg court was going to try and determine what happens to. So they applied to the English court for an anti-suit injunction. Now, some of you will be familiar with the legal threshold for an anti-suit injunction, but just to recap very quickly, the English court has power under Section 37 of the Senior Courts Act to grant an anti-suit injunction in relation to proceedings brought in breach of an arbitration agreement, even if no arbitral proceedings have been commenced or are in prospect. The applicant must demonstrate that there is a high probability of success that the foreign proceedings are in breach of an arbitration agreement. It is then for the respondent to show a strong reason why the anti-suit injunction should not be granted. And finally, it is in the court's discretion to grant the anti-suit injunction. And in exercising that discretion, the court will have regard to whether it is just and convenient to grant the injunction. In the present case, the arbitration agreement in the contracts were very wide, and it basically referred in a normal way to claims under or in connection with, which I think is fairly standard wording these days in a lot of arbitration clauses. The English court said that there is no presumption that an arbitration agreement does not extend to claims which only arise in a company's insolvency. And so the English court granted the anti-suit injunction in this case. And again, the English court was comfortable that where the arbitration agreement provided for a London seat, arguments that the English court is not the appropriate forum to grant the anti-suit injunction are extremely challenging. So again, the jurisdiction challenge there failed because the seat was England. Finally then, just some concluding remarks to sum it up. On my next slide, what I've done is I've sort of set out for an English company where a debt is governed by an arbitration agreement, it is appropriate for the court to stay or dismiss a winding up petition without investigating whether the debt is disputed in good faith and on substantial grounds. Initiating foreign bankruptcy proceedings in contravention of English law or English-seated arbitration agreement could be subject to anti-suit injunctions. Where parties enter into arbitration agreements, they will need to have their disputes determined via that forum, save in very limited circumstances. And finally, some practical considerations. If you're the claimant, where you're seeking to recover a debt that is subject to an arbitration agreement, you must give careful consideration to the way in which you seek to expedite your recovery. Various arbitral institutions have mechanisms in their rules for expedited proceedings and for emergency relief, which may be better suited rather than failed attempts with insolvency processes. If you're the defendant, on the other hand, where a dispute is subject to an arbitration agreement, it should be possible to head off an application for a winding up petition by making clear that the debt is contested and you require the dispute to be resolved by way of arbitration. And last but not the least, ignoring the problem will not make it go away. And equally, taking drastic but misguided measures will not always result in an effective recovery. On that note, I'll hand over to Alipak to talk to us about the Indian law position. Over to you, Alipak.
Sure. Indian law position is a little different than what possibly Kushal said. I think things were obviously very different till our insolvency and bankruptcy code came in December of 2016. So hardly 3-4 years of practice. Before that, in the general winding up provisions under the Act, things were very different. But still, there was no clear bar of starting a winding up petition just because you have an arbitration agreement. The threshold was always whether there is a genuine dispute or there is no genuine dispute. Winding up court were going into that issue in detail rather than simply relegating it back to the arbitration. But that regime, in my view, completely failed for several reasons. And insolvency and bankruptcy court came up as a handle of recovery of amounts, where even 5 lakh rupees claim and 10 lakh rupee claims, people started filing bankruptcy petitions and basically getting paid, settled, rather than going through the full process of arbitration. And it became very, very pro claimants rather than borrowers. So India, you have a pendulum which keeps swinging between claimants and rather lenders and borrowers, or claimants and creditors and debtors. And last 30 years, I think borrowers have got their way out. In spite of our debt recovery measures, in spite of our SURFACE, the security enforcement measures, and in spite of other stringent laws for banks and lenders, still borrowers, judiciary has generally given a good handle or a long rope to borrowers, basically to survive in a way. But I think the pendulum has now completely shifted in favor of creditors. Of course, the insolvency code has been suspended post-COVID. So today you can't make those applications. And we think that post-COVID era would be very different. The pendulum may come back a little in balance for the borrowers, considering everybody is aware that things have gone wrong for a lot of borrowers. So maybe with that background, Alipak, if you can bring in the aspects which Kushal touched upon from an Indian context, and also where do we stand today, and what is that India thinking in future for the cross-border insolvency aspects?
Sure. Thanks, Vapak. So as Vapak rightly pointed out, the insolvency code came in 2016, and we have had, this was a complete change, and we have seen a lot of jurisprudence, but it is still evolving. Now, the first point which I want to make is that in India, as such, the existence of an arbitration agreement or the pendency of an arbitration does not bar initiation of an insolvency proceedings. I think one is the right in rem and the other one is right in personam. So there are many judgments on this point. And so what needs to be looked at is whether there is a dispute or not. And that is the threshold which typically courts look at when they receive applications for initiation of insolvency. So that was at the outer threshold. Now, as regards interplay of arbitration and insolvency, even under the code, there is no provision as such. Even the Arbitration Act does not contemplate any situation like that. The only exception being as soon as the insolvency process gets admitted, a moratorium order is passed, which sort of freezes all existing or the ability to initiate new litigation or arbitration. And I'll deal with that in a minute. But before that, I think broadly it's very important to understand how the code works. So maybe in a minute I'll try to explain it, and then we can see how the interplay has worked in last couple of years and the gray areas as well. So under the code, basically there are two types of creditors: a financial creditor or an operational creditor. They can initiate insolvency proceedings, so they can file before the adjudicating authority, which is the National Company Law Tribunal. Upon notice, if the case is admitted, then a public notice is issued, and after that, a moratorium order is passed under Section 14 of the Insolvency Code. Now, subsequent to the moratorium order, in fact, the same order, an interim resolution professional is appointed who takes custody of the entire company, and thereafter, after going through the records of the company, it is advertised, and in the investors, which is called the resolution applicant as per the terms of the code, they have the ability to bid for the corporate debtor. And then once the bid happens, then the creditors of the corporate debtor, they constitute a committee which is called as a committee of creditors, and by 66% vote, they can apply their commercial wisdom and decide on a particular bid, whether to accept that bid or to reject that bid. There could be multiple bids, and then the process continues, and if there's a successful bid, then the corporate insolvency resolution is successfully completed, and then the matter finishes. In the event the resolution does not happen, then the corporate debtor moves into what is called as liquidation. In liquidation, of course, the aim is to sell the corporate debtor at a going concern, and there are mechanisms prescribed how you sell. So this is the broad framework. So at the outset, as I explained, the moratorium order, which is done pursuant to a public announcement, it basically declares it basically prohibits institution or continuation of all suits, proceedings against the corporate debtor, or for creating any or transferring any of its assets. Now, the Supreme Court has also held that matters of insolvency cannot be arbitrated. That's just a side point. Now, let's look at what is the scope of the moratorium order. So it is important to understand, does this mean whether all arbitral proceedings get stalled, or do you not have the ability to continue, or there are certain exceptions? Statutorily, there are no exceptions, but yes, case laws have evolved. Like the rulings, what comes out of the rulings is that to the extent the litigation or the arbitration is beneficial for the corporate debtor, it can be allowed, or to the extent it leads to asset maximization of the corporate debtor, such proceedings may be allowed, and nothing more than that. And there are a line of authorities on this, the National Company Law Appellate Tribunal and also the Supreme Court have ruled on these issues. So just to cite the citation, Alchemist Assets Reconstruction Company, this is a Supreme Court decision. They have clarified that the limited instances on which you may continue with the arbitral proceedings. And in fact, NCLAT also in a couple of decisions, they have said the same thing. Now the question comes, okay, fine. I mean, you can't initiate arbitration, you can't continue with the arbitration unless you come under very limited window. What happens to enforcement of arbitral award? That's also a very important question. Now, again, enforcement actions have also been barred, but there is one case decided by the Delhi High Court in Power Grid Corporation of India versus Jyoti Structure, where a Section 37 application of the Arbitration Act, under Section 37, you basically challenge the arbitral award. That was allowed because, again, if the challenge was to be successful, that would have benefited the corporate debtor. So again, the jurisprudence is the same, but even in the context of a challenge to arbitral award, a limited window was granted. So now the next question can be, okay, so you can't do anything with your arbitration, but do you have the ability to participate in the corporate resolution process? I mean, a lot of clients, they come to us, they say that I can't do anything with my arbitration till such time it is resolved, till such time the corporate insolvency process is resolved. So what do I do next? Now, again, yes, it is possible for a claimant in the arbitration proceedings to participate in the corporate resolution process, and there are prescribed forms under the code by which you can participate, provided the underlying agreement which you had with the corporate debtor that entitles you to be a operational or a financial creditor. So the test is of the underlying agreement. I mean, it is basically commencing a fresh proceedings again, and then again it has to be looked at whether there was a dispute or there was no dispute, and there are various other thresholds. Assuming you qualify the threshold and you participate in the process, then then the insolvency resolution professional, he has the right to either accept your case or to reject your case. If he rejects your case, then you can move before the National Company Law Tribunal and agitate. I mean, and there are further line of appeal leading to the Supreme Court as well. If your case was to be accepted, then your claim value will find mention in the information memorandum which the resolution professional will prepare. An information memorandum is just like a brochure which will be presented to the incoming investor so as to tell them to invest in the corporate debtor. So your claim will find mention over there, and then thereafter it is up to the incoming investor as to how they will treat your claim. So this is very important. This is, I think, very peculiar to Indian law. So if the incoming investor decides that against a pending arbitration of $100, they are $20, and if that proposition is accepted by the committee of creditors, which comprises of the financial creditors, and if that is voted in favor by 66% or more, then that stands binding on everyone. And of course, I mean, after the resolution plan is accepted by the committee of creditor, you have to place it before the National Company Law Tribunal for approval, but that is more of a process. Now, so you are effectively in the hands of the resolution applicant or the incoming investor and the committee of creditor. Now, there are also situations, and this is the more likely situation, at least in 95% of the cases, what happens is the incoming investor will negotiate a clause in the resolution plan, which will say that all existing litigation stroke arbitration will stand extinguished as and when new further capital is infused in the corporate debtor. And these clauses have been now upheld by the Supreme Court. A recent example being the SR Steel judgment by the Supreme Court, which was rendered earlier this year. So you are effectively looking at, if you have an arbitration, if you have an ongoing arbitration, or which is barred or which is stalled by the insolvency, the initiation of insolvency, at best you will get maybe 10 or 15% of your claim value if the resolution applicant is very kind, or the more likely situation is it will give you nil value, because by the clause which will extinguish all pending litigation, your claim will get extinguished. So that's where we are. Now, one caveat to that is, assuming that there is a successful resolution, then you have the ability to continue with the pending arbitration, provided in that situation that clause of extinguishment of all pending litigation arbitration does not feature in the resolution plan. So that's where we are as regards the framework. Yeah, so that's the broad framework. We have not had many cases. The code is still at a very early stage. We do have certain cases as to how arbitral proceedings are to be treated, but as we expect the jurisprudence to evolve. There's also another aspect as to whether a valid arbitral award can be a proof of debt in a insolvency proceedings. Maybe I'll take this up a little later during the discussion, and we'll address that as well.
Sure. No, thanks a lot, Lipak, for giving a overview of what stands today in India, which usually is more complicated than most of the jurisdictions, so it's not easy to understand fully. But I think the short point one needs to take into account is now Insolvency and Bankruptcy Code 2016 of India takes primacy over a lot of such pending arbitration or even pending claims, And as Alipak was saying, that you can actually be told that your claim is valued at zero by the incoming investor who wants to take over this company, and you have no say at all to say yes or no, so long as the secured or the financial creditors agree, which means your claim goes away. This also answers a couple of questions from Bharat Chaudhary in terms of primacy, and I think Alipak has already dealt with both the questions. If something is pending, Bharat, you can put your question again as well.
So
And I think we have
one quick point which I missed, and this is a common query which we receive is, in case the insolvency process has been admitted in India, what happens to foreign seated arbitration? Because in the last 10 years, most of the India contracting parties will have their disputes seated in Singapore or London. It's a very common thing, right? So India does not have reciprocal arrangement. The Indian Insolvency Code, under section 234 and 235, we don't have reciprocal arrangements with any sovereign state. What we follow is an ad hoc protocol. There are a couple of cases on an ad hoc basis that has been done, like in Videocon Industries or Jet Airways case. What that means is that the ability of the particular debtor to the moratorium order from the Indian court and to have it enforced in a foreign jurisdiction or the foreign seat of arbitration is very difficult. And in that situation, foreign tribunal as such may take a view that they don't need to bar the proceedings. Of course, there could be problems in enforcement, but that is a different discussion altogether. As a matter of law, since ipso facto there is no recognition, a foreign arbitral tribunal is well within their rights to take a view that the proceedings will not get barred.
sure.
Yeah.
So that gives a very good cue for bringing in Emily on the issue of cross-border insolvency and recognition of foreign insolvency proceedings in England. I think Kushal did touch upon a different situation where the seat is in London and insolvency is happening outside London. Emily, if I can bring you in on the aspects of recognition of foreign insolvency proceedings in England, and also your other experience dealing with this overlap.
Thank you very much. So yes, I'm going to talk to you very briefly about the English law position. And we like to pride ourselves in England that we're very welcoming and we want to try and help in foreign insolvencies. So let me just give you a quick overview of where I'm going in the next 10 minutes with this talk. So firstly, I'm going to outline how foreign insolvency proceedings are recognised in England and Wales, and then what effect the foreign insolvency has where either English law applies to an arbitration agreement or the seat of the arbitration is in England. Now, there are four ways in which you can get a foreign insolvency from an English perspective recognised in this jurisdiction. And I've set them out on the slide. The first way, and this is in order of precedence, so the way in which the courts will look at it if there's any kind of conflict. The first is the European Union Insolvency Regulation. The second is under the UNCITRAL Model Law. Thirdly, we've got a piece of domestic legislation, the Insolvency Act of 1986, which has got a particular provision that deals with recognition of foreign insolvency proceedings. And then if all else fails, you can fall back on the common law rules. And each of those, I'll go through very briefly how they work and what effect they will have on an arbitration agreement or a seat of arbitration in London or somewhere else in the UK. So let's start with the EU regulation. I've set out the full name of the regulation on the slide, just in case anyone might need to know at some stage. It's a recast regulation, so it's the second version of the regulation, and it applies automatically to all EU member states, apart from bizarrely Denmark. And the key point in terms of the way this regulation works is if you've got a debtor company in a member state which has got its centre of main interest, so it's the presumption is its registered office where it administers its business. If an insolvency is started in that company's centre of main interests, in the member state where the company has its centre of main interests, those proceedings are recognised throughout every EU member state as the main proceedings. Now that means that, for example, if it's a liquidator in that member state, that liquidator has got the right to go to other member states and exercise the same rights that he or she has in his own member state in those other member states. So it's very much a harmonisation of the entire insolvency process for a company which might have assets in a different member state. Other insolvency proceedings can be started in different member states, but they will only govern the position with assets in those member states. So once you've got an insolvency going on in the COME, the Centre of Main Interest member state, that's it. It sets out the mandatory rules on choice of law, jurisdiction, recognition, and enforcement. Now, I've set out a little note on Brexit there. I'm sure you're all aware we voted to leave the European Union in 2016, and we actually left at the end of January this year. We're in a transition period at the moment, where we're trying to come to a deal on various trade points with the EU. Currently, these new regulations, the Insolvency Amendment EU Exit Regulations 2019, will come into effect if there is no agreement reached with the EU in terms of insolvency, and it will mean that there's no automatic recognition of EU insolvencies in the UK and no reciprocity. So for EU insolvencies, we'll have to fall back on the other methods of recognition. And onto the next slide, I've just set out, in case you ever need to know, what happens specifically in terms of the EU regulation. So as the first point I've already mentioned, the law of the state where proceedings are open determines the effects of the insolvency proceedings on current contracts to which the debtor is a party, and that will include arbitration agreements unless you've got proceedings ongoing. And secondly, the law of that state determines the effects of the insolvency proceedings on proceedings brought by individual creditors, again with the exception of pending lawsuits and pending arbitrations. And those are dealt with by Article 18. And that says that the effects of insolvency proceedings on pending arbitral proceedings are governed solely by the law of the member state in which the arbitration has got its seat. So if you've got an arbitration going on in London and an insolvency happening in, say, France, the arbitral tribunal determines what happens in respect of the arbitration. So that's the position in the EU under the EU regulation. So let's move on to the model law. I'm sure you're all aware, so the UNCITRAL model law is the product of a collaboration between the UN, the Commission on International Trade Law, and INSOL International, the International Insolvency Body. And the idea is to provide this harmonised cross-border approach to insolvency where you've got an insolvency going on in different jurisdictions. And we in the UK, we've adopted the model law under these cross-border insolvency regulations. So if you've got an insolvency going on in a different jurisdiction, the office holder, the insolvency practitioner in that jurisdiction, has to make an application to the English court to get the insolvency recognised. Now, as soon as the insolvency is recognised in this country, that automatically stays any ongoing arbitration. The UNCITRAL model law, as I'm sure you're aware, has been signed up to by a number of different countries. Unfortunately, India isn't one of them at the moment. But I've said that you get a stay of arbitration proceedings automatically. Onto the next slide, I've set out Article 20, subsection 6 of the cross-border insolvency regulations. There is a discretion to apply to get the stay lifted, and it doesn't have to be the foreign insolvency practitioner who can do that. Anybody who is affected by the stay can do it. And I've set out the case of Recombinat on the slide. Now, this was a case where a company in Montenegro had entered into some financing arrangements and various other contracts with a bank. And the contracts were all subject to arbitration seated in London. Now, the company went into an insolvency procedure in Montenegro, and immediately the bank said, well, you've breached these agreements. We want to start arbitration in London. And they did. They started arbitration successfully in the LTIA. The insolvency practitioner in Montenegro, to stop all this happening, applied and was successful in getting the Montenegrin insolvency recognised in this jurisdiction, which had the effect of automatically staying the arbitral proceedings. And the bank made an application to the London court to get that stay lifted, so that it gave the English court to look at the discretion that it had. And it was a first instance decision. The court said it had a free hand to do what was fair and right in the circumstances, so it gave itself very broad powers. but it said that the discretion would have to be exercised in accordance with the aims of the model law. So to ensure that creditors got their fair share of the debtor's assets. So that's the model law. Moving on to the third of these four ways you get recognition in foreign insolvency proceedings. This is section 426 of the Insolvency Act over here. And subsection 4 says that whether UK courts have got jurisdiction in any given insolvency, for example, if there are assets in this jurisdiction, the English courts will assist specified countries that make a request for help. So it's a two-stage process. Firstly, the person who is responsible for the foreign insolvency has to persuade their home court to make a request of the English court for assistance. And then that request has to be considered by the English court, and they have to decide to provide the help that is being asked for. Now, there are a number of countries to which this applies. Unfortunately, again, India isn't one of them. It's all set out in a piece of secondary legislation. The snappily titled Cooperation of Insolvency Courts, Designation of Relevant Countries and Territories Order. So there you go. Now, section 426 of the Insolvency Act is interesting in that the UK court can apply its own law to the request, or it can apply the law of the country that's made the request. And I put a couple of examples on the slide. So this means that you can, as a foreign insolvency practitioner, you can get English law remedies in respect of your foreign insolvency related to assets in the English jurisdiction. And it includes things like worldwide injunctions. And that was what happened in Hughes and Hanover. This was a request from the Supreme Court in Bermuda for a worldwide injunction, which wasn't in the end acceded to by the English court. The English court said matters had moved on since the request was made. But nonetheless, the court didn't say you can't get this kind of relief. It is very much available. The second example is England and Smith, which is another Court of Appeal authority. And in that case, there'd been an insolvency of a company in Australia, and the insolvency practitioner wanted to examine an auditor who was in England. So the Australian court, South Australian court, made a request to the English court to examine this guy, this auditor in the UK. And if they'd made the request and applied English law, they wouldn't have got the order. But the Court of Appeal said, no, you can, under this Act, section 426 of the Insolvency Act, you can apply and should apply Australian law. So they got the order to examine this auditor. So that's our domestic law, domestic legislation. But if all else fails, if you can't use any of that, you can fall back on the common law. Now, as you would undoubtedly expect with England, we like to think that this is nothing new. And Lord Hoffman set out the position in 2008 in this case of HIH casualty and general insurance, noting that this cross-border bonhomie and general trying to help everybody out dated back to the 18th century. He said the principle requires that English courts should, so far as is consistent with justice and UK public policy, cooperate with the courts of the country in the country of the principal liquidation to ensure that all the company's assets are distributed to its creditors under a single system of distribution. And the common law position was considered more recently in the case of Rubin Eurofinance, which I put up on the next slide. This was Lord Collins in the Supreme Court, who again stated the position very broadly. He said recognition and assistance may be given by the English court to foreign office holders in insolvencies with an international element. And it's basically done on a case-by-case basis. The court will apply English law remedies. The sort of assistance that has been given has been remitting assets to a foreign office holder and staying proceedings because of foreign insolvency. So this would apply in arbitration. If you have a foreign insolvency and you want the arbitration in London to be stayed, you can make an application to the court using the common law. So as hopefully you can see at this very high level, I've just run through very briefly, we've got a range of tools available to the courts over here to help in foreign insolvencies. In terms of what happens in arbitration, the general position seems to be that the arbitration will be stayed, but that might not be the end of the matter. So with that, I'm going to hand over to Abhinav, I think, who's going to talk about things from the institution's perspective.
Yes, Abhinav, why don't you come in? I think you have patiently heard all over the world, knowing pretty much all the jurisdictions. But I think at the end of the day, you deal with it from an institutional perspective and also see the real effect on the arbitrations? And do you think things have changed? What was there in 2007-8 when also we saw a lot of insolvencies to what we are seeing now in 2020? How institutions have responded to these situations to ensure there is a, any way extent it can be taken care of. So your views on that would be very much helpful. Thank you.
Thanks, Vyapak. And I wouldn't go as far as that I know what's happening in the world everywhere. But yes, I think when you're at the ICC, you do get sort of a bird's eye view of what's really happening and how the tribunals are dealing with it. When it comes to us at the ICC, I think when you're especially administering cases which have an element of insolvency involved, our ears definitely go up right from the very first instance. So, for instance, all things considered, of course, matters of substantive and procedural matters do rest with the tribunal. So if we get a case today where insolvency is pleaded or insolvency is suggested, then of course we will go through with our prima facie check under Article 6. But the issue of whether this matter will be arbitrated, should be arbitrated, or could be arbitrated, we will let that with the tribunal, of course, in adherence with the competence principle also. But before we do any of that, what do we really do? Before the tribunal is constituted, we have to be sure to know as to who is the insolvent party being represented by. Because that's a dark hole, it's a black hole. You don't know. You get a request, and now you don't know who to send that request to, who's representing the party, and how to go about it. So obviously we notify it as much as on the addresses that are available in the contract or the addresses that are otherwise available to us from the claimant party. It is also the question of Article 17 of the rules, where after the constitution of the tribunal, sorry, am I audible?
Yes, Abhinav.
Yes.
Very well.
Thank you. After the constitution of the tribunal, the tribunal is mandated or can ask for the power of attorney from the party that is either insolvent or going through such proceedings. Several tribunals, what we've seen with respect to the continuation of the proceedings, or rather the suspension of the proceedings, have held that continuity as such is arguably a matter of lex arbitrae, and therefore perhaps a more procedural ground, and have proceeded to continue with the matter. One such case that comes to my mind, there was a case between a Korean party and a Japanese party where the seat of arbitration was Japan, but the Korean party was going through liquidation in Korea. The tribunal in that particular case held that, look, yes, the Korean laws, the Korean insolvency laws do not extend extraterritorially, and therefore, because this arbitration is being held outside of Korea, we will proceed with the arbitration. Japan, Tokyo was being the seat of arbitration. In jurisdictions where, perhaps like India, where it gets tricky, where insolvency is not strictly arbitrable, or where the jurisprudence is still evolving, do we go ahead and constitute the arbitral tribunal? Like I said, yes. In all such cases, we will go ahead, constitute the tribunal, make sure that the other side is represented well, and then leave it to the tribunal to decide on its own jurisdiction. Have tribunals proceeded with such cases? Generally speaking, like I said, mostly yes. Whether they come from the European Union or they come from the Americas, several cases seated in different jurisdictions, what the tribunals have done is they've taken a call. They've taken a call, perhaps they've dissected the issues in a way that whether this dispute is arising out of the contract or whether the dispute is coming out of the insolvency. So insofar as the dispute is coming out of the contract, the parties they've given party autonomy, sort of the precedent over the insolvent part of it. Insofar as the dispute is coming out of the insolvency, that's where it gets tricky, and the tribunals have been more cautious about it. The other thing that we are very careful in telling the tribunals is during the award scrutiny. Almost always inevitably draw the tribunal's attention to the fact that, look, have you considered and deliberated on the issue of insolvency in the award or not? The other very important thing that as the Secretariat or the ICC court that we look into is the concept of due process. It is critical, I think, for an administering institution, which perhaps would not happen in an ad hoc arbitration, is to make sure that the parties are given the right time and the opportunity to present their cases. Sometimes the tribunals get impatient, perhaps, or the tribunals are hasty in coming to a decision. And I think that's where we do this check and, the stop check balance as to informing the tribunals in making sure that they give an opportunity to the tribunals, to the parties to present their cases. There are different jurisdictions that I can go into: France, England. I have examples from Greece. I have examples from New York. But I can say, if I were to generalize it, perhaps wrongly so, but if I were to dare to generalize it, most tribunals have gone ahead asserting their jurisdiction on the matter. What the tribunals have also said is that, look, our job is to adjudicate the matter. Some of them have gone said that enforcement is not really their problem. They will go ahead and adjudicate the issue as the parties wanted them to do so. And then enforcement is left to state courts and national laws as to how they want to really go about it. So these are my sort of brief comments on how we look at insolvency proceedings and what we anticipate in 2021 because of the after effect of COVID-19. Although I must say that, as counterintuitive as it may sound, the year 2020 has been a windfall of cases for most arbitral institutions. I think most arbitral institutions may hit their record numbers in 2020 for new cases, although I suspect that may not be the case in 2021. A lot of countries, a lot of governments, a lot of banks have given moratoriums, have given relief packages to different companies around the world. Those moratoriums, those relief packages may not be in existence next year. And therefore, the real effect, the real impact, the financial impact of COVID-19 may actually be felt in 2021 or maybe even beyond that. And therefore, I suspect that we may see rise in arbitrations related to insolvent parties like a never before in 2021 or 2022. Which also helps because starting 2021, the ICC will start publishing all its awards unless one party objects. So suddenly we will see in 2021 going forward, you will see a host of sort of arbitral jurisprudence coming out of the ICC, which will include jurisprudence about insolvency. There is already enough literature on extracts from insolvent awards, awards which had an insolvency issue. In fact, there is a 2009 publication which has a host of ICC awards, extracts of which deal with different issues related, decided by different tribunals in different jurisdictions on insolvency. And I would actually encourage people to have a look at that publication, 2009 ICC Bulletin, or reach out to me if they need the specific citation. So those are my brief comments. Thank you.
Thanks, Abhinav, for that and very clear understanding as to how institutions look at this. There is one question from Varat Chaudhary. Any specific case law to determine primacy of IBC? I think if Alipak, you want to touch upon
Sure.
this question, maybe SR Still and others.
Sure. So the first point is Section 238 of the code, which basically says that this provisions of the code will prevail over anything else. That's the first starting point. And thereafter, the Supreme Court in Alchemist Assets Reconstruction Company, AIR 2017 SC 5124, they have basically said that arbitration or related court proceedings commenced after initiation of CIRP are considered non-est in law. And there's a lot of discussion on the interplay and all of that. There are also cases several cases on NCLAT as well, relying on the Supreme Court decision on this issue.
Understood. So thanks a lot, Alipak. I hope that answers one question from Jeffrey. And I think Kushal has already answered it, but by putting it on the chat. But Kushal, if you want to elaborate on your answer, how has the London Court Authority in St. Petersburg? If you want to just touch upon that. And I also request other participants, if they have questions, please feel free to put it on the Q&A window. We'll try and take it up in next 5 to 10 minutes.
Great, thanks, Aripak. So just to remember, the question is, how did the London Court of Authority in St. Petersburg, and I think this is referring to the River Rock case that I mentioned, where the English court granted an anti-suit injunction. So what happened in that case, obviously, is that the English court ordered an anti-suit injunction, which was against the parties to the claim in the English court. So the English court was exercising jurisdiction over the parties that were in front of it in the English court, and therefore it prevented them from bringing a claim in a foreign court. Breaching the order puts the parties in contempt of court in England, and that then creates a mechanism which allows the English court to grant an order trying to prevent proceedings in a foreign jurisdiction by exercising jurisdiction over the parties as opposed to over foreign courts. And so it doesn't affect the sovereignty of the foreign courts as such. I hope that explains that.
Sure. There is also a question from Mariam. In a post-COVID era, given the amount of loans made by government, especially to small and medium enterprises, would there be a push to settle compared to go for liquidation? I think so. That would be a general trend. Like other insolvency situations where economic downturns, which were purely due to commercial reasons, and also sometimes limited to certain jurisdictions, certain sectors, not everyone got it at the same level. In this situation, I think everyone knows that it has applied to almost the whole world evenly. I think we would see a lot more resilience and settlement rather than people, triggering arbitrations or disputes straight away. But then it's a matter of, time, how long you can wait, and whether there is a settlement even possible. Eventually, one would not let go their legal rights. There are other implications to that. So I think it would be a combination, but we'll see how it.
So Vyapak, one interesting point which I left out, two cases which I really want to point out, one by Supreme Court and the other one by NCLT Bombay. This is regarding how do you treat an award? Can you treat it as a valid claim? Supreme Court has clarified that claim has to be undisputed. The award has to be undisputed. And this is K. Kishan versus Vijay Nirman Company. This is a 2017 judgment. But a similar case came about very recently before NCLT Mumbai, and they were considering a foreign arbitral award. And in fact, a foreign arbitral award, because it was not challenged at the seat of arbitration, that was used to initiate insolvency proceedings against corporate debtor. So basically, instead of filing enforcement proceedings, in that case, insolvency application was made before NCLT Mumbai, and that was allowed, that was accepted. We have to see whether that will get appealed to NCLAT, but that's a very interesting judgment, which came out, I think, about a month back.
To Emily, on the aspects of enforcement, I know there has been some updates on that law as well. We are already 1 hour into this webinar, but maybe very quick, few minute comments on that from you, and maybe then follow up with Kushal, and then final comments from Abhinav.
So in terms of enforcement, you have to go through the same, if you've got a foreign arbitration award, you go through the same procedure that you would as in any situation. look at the New York Convention, try and get it enforced in this country. And if you're up against an insolvent counterparty, you simply become, assuming the debtor is unsecured, another unsecured creditor, and you're subject to the same rights as all the other unsecured creditors of the counterparty in this country. You might be referring to a judgment that came out in January, possibly, where it was held that you couldn't get recognition of a foreign insolvency if the company wasn't actually insolvent. Maybe.
That's what I was.
But in terms of arbitration awards, it's the same as it would be in any arbitration award. You get it enforced in this jurisdiction, and then you take your chances with the rest of the creditors over here. So it's the same problem you have in any situation, whether it's litigation or arbitration against an insolvent counterparty. How much time and money do you want to throw at the problem? Which I suppose depends on the specific circumstances of the debtor.
Sure. Kushal, any thoughts, final comments from your side, any pointers that you would want, the do's and don'ts while you are facing this two parallel situations in a dispute?
I think what I would say is, don't ignore the problem. Don't be passive. Try and be fairly active in how you're dealing with the issue, whether you're the claimant or the defendant. As we've heard today, there are lots of mechanisms, there's lots of help out there that can be obtained. And actually, having a cross-border strategy can be very effective and very important. And it doesn't have to be expensive to deploy that. And as we've also heard from Abhinav, you can get help from institutions as well. So, it is a very robust process. And to make sure you get recovery quickly, do that in mind in having an overall cross-border strategy.
Yeah, I think there is one more interesting question. Maybe Dilpak, you can take that, and then I can go finally to Abhinav. It is, I think, from Madhvendra. Is if the contract is governed by Indian laws, how the insolvency proceedings abroad would bind the company under Indian law? I think this again goes back to your point on applicability of proceedings either ways. Depends upon where it is, but maybe Alipak, you can give a very quick 2-minute answer on that.
I think in terms of foreign insolvency, to the extent it is, if it can be recognized in India, then there could be a problem. But India as such, do not have reciprocal arrangement, which we just explained. But it could be recognized on an ad hoc basis, like this has been done in 1 or 2 cases. So it depends on facts and circumstances.
Final comments, Abhinav.
The final comments, I think much has been covered, but perhaps I'll take the opportunity to say that some of the new rules that are coming into effect from 1st of January 2021, the new ICC rules, the formal launch of which is on the 1st of December, would further perhaps aid arbitrations where there is an insolvency element. For instance, the joinder provisions have been changed. Now a party can be joined even after the constitution of the tribunal, if the party which is being joined agrees to it, which wasn't possible before. The authority, the power of attorney rule the title has changed. Now the parties are obliged to immediately inform the tribunal, the secretariat, and that goes for arbitrations which do not have an insolvency component either. They are obliged now to immediately inform about any change in representation. There is a slight change in consolidation as well, and I think all these things will further aid arbitrations related to insolvency, because whether we like it or not, insolvency is here to stay in 2021 and beyond. And let's see how things unfold.
No, that's true. I think there has been a lot of discussion, the new rules of ICC, and I'm sure you would be doing a lot of road shows, maybe virtual road shows in this time.
Yeah.
But people are looking forward to see how those new rules would, interact with the current regime, and also, help the process of arbitration. So we look forward to some of those sessions, and I'm sure participants also would be looking forward to it. So thanks a lot. Thanks a lot, Emily, Kushal, Abhinav, and Alipak for your kind time and giving your expertise on this. Thank you all the participants for joining today and staying on. This is a topic which obviously can be discussed much longer, but we thought we'll at least touch upon few important ones and some of the latest judgments are dealing with these issues. And as the law develops, we'll definitely come back with more updates on this topic as well. So thanks a lot. Thank you, everyone. Have a nice time and have a good weekend. Thank you.
And you.